Eyes, please.
This is the Kangaroo Court of the 4th Judicial District, the state of Idaho, and the county of Ada. Judge Roy Bean presiding. All sit down, please. Well, looks like we've got a full docket today. Let's see what's first on the list. Would you identify yourself, sir?
Yes, I'm Jim Hill with the Ada County Prosecutor's Office.
Are you here to represent the state today, Mr. Hill?
Yes, I am.
Okay. The first case I have before the court today is the case of Jim Muckelschmutz versus the state of Idaho. The state of Idaho versus Jim Muckelschmutz. Is Mr. Schmuckelschmutz in the courtroom, please?
I don't think he's here, Your Honor.
Did you know that he wouldn't be here? Is there some reason for his absence? Do you know it?
I guess he was one of those typical types that we run into every so often.
Okay, well, that being the case, we'll just issue a bench warrant. We'll pull him in. Okay, do that to the clerk later. Okay, the next case before the court is the state of Idaho versus Neelis Cook. Mr. Cook, are you in the courtroom?
Here.
Well, would you take the defendant's table? See, Mr. Cook, I have you down here for a court trial today on the failure to operate a vehicle without registration and failure to purchase insurance and failure to show. Is that correct?
I guess so, Your Honor.
Okay. Well, those are the charges I have before the court. Is that what you're here to defend, Mr. Cook?
Yes.
Okay, fine. Are you ready to proceed, Mr. Prosecutor?
Sure am, Your Honor.
Okay, would you like to start out then with your opening remarks, or how do I handle it?
Well, Your Honor, we have an offense against the state of Idaho by Mr. Cook here. He apparently believes that he doesn't have to obey the law of the state. He doesn't have license plates on his car. He doesn't carry any registration or proof of insurance or even a driver's license. And so we're ready to proceed on those grounds.
Is that the extent of your opening remarks, Mr. Prosecutor?
Well.
Okay. Mr. Cook, would you like to make your remarks this time, or would you like to...
Oh, I think I'll wait till I start my case.
All right, fine. Proceed, Mr. Prosecutor. Call your first witness.
Okay, Your Honor, we would like to bring in Officer Dempsey to the witness stand.
Officer Dempsey, if you'd face the clerk, please, to be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Now sit down over here.
Officer Dempsey, could you state your full name, please?
I'm Officer Rusty Dempsey. I'm a sergeant with the Boise Police Department.
And how long have you been in that position?
5 years.
5 years. And could you give us a little background information concerning where you were at the time of the alleged offense against Defendant Cook?
I was moving north on Capitol Boulevard, crossing the intersection right at Front Street, when I noticed a vehicle, which was very obvious didn't have a license plate, traveling from east to west on front. So therefore I pulled in, and by the time I got in behind the suspect vehicle and turned on the lights, I pulled him over at 6th and Front Street.
Okay, now this all took place within the city limits of Boise City, is that correct?
That is correct.
Okay. Now, what did you notice when you pulled him over? What was the reason that your probable cause was to bring him to the stop?
There was no license plate displayed on the back of the vehicle.
Back of the car, okay. And then you did stop him and proceed to question him for the reason?
Yes,
for the license plate?
That is correct.
Okay, and then what else did you discover in your questioning the defendant?
In the question, I immediately asked him for his driver's license.
And what happened?
He informed me that he did not have a driver's license.
He didn't even have a driver's license?
That is correct.
Now, did he give a reason for that?
He mumbled something about he was a free man, or that he didn't need a driver's license
I see.
to use the streets.
Did he have an expired license, or just would refuse to cooperate? Is that correct?
His statement was he did not have a driver's license.
I see. And what about the insurance proof? Did he offer that to you?
I asked him if he had proof of insurance, and he said he had that. He did not have that either.
I see. And then at that point, what did you proceed to do?
Oh, he mumbled something about Constitution and this type of thing, and we've run into this type before. So I just issued him the citations for no registration, driver's license, or proof of insurance.
I see. Okay. Cross-examination?
You're through.
I think I'm through for now. Yes.
Okay. Mr. Cook, would you like to cross-examine, please?
Yes, I would, Your Honor. Mr. Dempsey, is that correct?
That is correct.
When you saw my vehicle, you noticed there were no plates, is that correct?
That is correct.
And you determined at that time that there was something wrong with the situation?
Well, I determined that there was no plate on that vehicle. That was my probable cause to stop you, Mr. Cook.
Is that a violation of some law?
That is a violation of Idaho state statute.
And is your position then in your job that every vehicle must have a license plate on it?
It is my job to enforce the statutes of the state of Idaho, and the statutes of the state of Idaho say that every vehicle traveling upon the right-of-ways of the state shall have a license plate and be registered.
Did you notice any other aspects about the vehicle? Was it a vehicle marked with an IPUC number, or was it a vehicle with a corporate name on the side, or was it a common carrier, or any of these things?
The only thing I noticed about the vehicle was a late model Ford pickup.
And it was not, the thing I'm asking is, were you aware of whether or not this vehicle was engaged in some kind of commercial venture upon the highway?
I'm not aware of what the vehicle was doing other than traveling down the street without a driver's license, without a license plate.
So it's simply a common vehicle traveling on the road?
That is correct.
Did you ask me at that time what purpose I had for driving the roads?
No, I did not.
Didn't I inform you that I travel as a matter of right?
Yes, I think you said something like that, or I don't really remember.
Do you remember me informing you that I was engaged in no commercial practices or commercial ventures on the highway?
I remember you come up with a lot of mumbo-jumbo or something about this thing, but I don't recall any of those exact words.
Do you remember much of what you said?
Yes, I remember that I informed you that all citizens in the state should have a driver's license, and they should register their vehicles and have insurance to protect the general welfare and health of the public out here.
Mm-hmm. Let's see. So after I informed you of these things, then you went ahead and gave me a ticket, is that correct?
That is correct.
Okay. And then, did I sign that ticket?
You refused to sign the ticket correctly.
How's that?
Well, you went ahead and signed it, and then you put some kind of under threat or duress or something. I don't remember those words about that. I don't remember the exact lines.
Under threat and compulsion.
I believe that is correct.
Thanks.
I'd have to have the ticket to verify that.
So I have no further questions, Your Honor.
Any redirect there, Mr. Prosecutor?
Concerning the ticket, isn't there a code that says that they cannot alter a ticket if it's given to somebody who violates a ordinance or a code, Idaho code?
Yes.
There is, and he did alter the ticket?
Well, I wouldn't say he altered it. He just added two.
He added to what was already on
What was already all we needed was his signature.
I see. And he proceeded to write some other words and so forth on the ticket. I see. Okay. I think that would suffice for now, Your Honor.
All right. Mr. Dempsey, I guess you're excused. Do you have another witness, Mr. Prosecutor?
Right now, I don't have any witnesses, Your Honor.
Okay. Well, does that complete your half of the case then? Or,
well,
any other evidence to bring before the court? Or?
As far as evidence goes, no, Your Honor. I think the state would rest at this point.
Okay. Mr. Cook, I guess you're on top.
Well, Your Honor, at this time, I'd like to make a motion to dismiss for failure of the prosecution to establish a prima facie case.
Oh, really? Well, let's hear your argument.
Okay, so the facts presented are insufficient on the face of the presentation for the reason that there was no cause established for the ticket. There was no cause established for Officer Dempsey to bring a charge of a criminal offense into this court. And, of course, as you know by the pretrial motions, my theory of the case is that absent any conduct of commercial enterprise, commercial venture upon the highways, there is no cause for this jurisdiction to occur under Title 49 of the Idaho Code, which is the traffic code. And absent any kind of conduct of commercial enterprise on the roads, then the driver of an automobile who drives as a common right, drives his own vehicle as a matter of right of way on the highways of the state, is not subject to this jurisdiction. Therefore, he is not to be regulated by the traffic code. And therefore, I challenge the prima facie case in that it has not alleged sufficient facts to prove an offense here. And therefore, the jurisdiction of this court is lacking. I think that states as well as I can. That's my theory of the case, and that's how I plan to appeal. But I still feel that the prima facie has been lacking, and no corpus delicti has been established. And there is one further element, by the way. The intent element is not shown here either. The intent that was shown to the officer, as shown by the testimony here, was an intent to drive as a matter of common right. And the absence of a driver's license, Your Honor, is not the guilty. It's not the fact that makes the defendant guilty in this case. It's the fact that shows his good faith. The absence of the driver's license is to be construed as the absence of any kind of criminal intent in this case. So the fact that I did not have a driver's license and I had never given my consent to be regulated in this manner in my exercise of a right on the road is the showing that there was no criminal intent, and therefore one element of this criminal jurisdiction here is lacking in this case. And I will ask that the court note for the record that the tickets were signed under compulsion and threat, and that is not a voluntary act, and it does not give consent to this jurisdiction. So consent was neither gained by the purchasing of a driver's license, nor was it gained by the signing of the ticket and the voluntary summoning of oneself into court, as the testimony shows and as the tickets show. So therefore, I believe that the prima facie case has failed at this point in time. I move for dismissal of the charges.
Okay. Mr. Roth?
Oh, and there's one matter of the ticket of failure to show the driver's license, Your Honor, and I'd move for dismissal of that at this time. It's obvious from the testimony here so far that I did not have a driver's license. None's been presented into the record, and yet I'm charged with failure to show. It should be a logical fact that if I had no license, I couldn't show one. So that charge falls on the face of it. I move for dismissal of that charge.
Mr. Prosecutor, would you like to rebut that?
Your Honor, Mr. Cook is a typical, what we call in the prosecution ranks of a constitutional fanatic, and this is their attitude. The state of Idaho is sovereign in this matter. This court does have jurisdiction. The legislature represents the people of this state, and the legislature is voted in by a majority of the people, and a majority of the legislature enacts the laws to govern and regulate. The state cannot tolerate just people running around willy-nilly all over at their whim and violating the laws that the duly elected representatives of this state have passed into being. And therefore, we would urge that the court deny any dismissal that the defendant would move, and we move that the court find this defendant guilty on the violations as cited: license plates, proof of insurance, and registration.
Okay, well, let's look at the codes here a little bit. 49125 shall be unlawful for any person to commit any of the following acts: to operate or for the owner thereof to permit the operation upon a highway of any motor vehicle trailer which is not registered. Okay, I think that's quite clear. The duty is there in the code in that particular one for the individual to get that. I don't see how, and just because a person does not engage in trade, commerce, and industry doesn't seem to be any exceptions under the exceptions listed under the subparagraphs of 49115, 117, 118, 120, and 125A and 206. I see no exceptions for any type of person in here that falls into the category that you presented to the court on that particular one, Mr. Cook. So I think there is cause for the ticket there, and there certainly was probable cause for the stop because there was no license on the vehicle. And let's see what the next one is here. 245. Okay, that's failure to insure every operator and driver. I think that's quite clear also. I don't see a problem with that. But the duty is there in the code also, and that you should do whatever you have to do to ensure that your vehicle is properly. I do notice that there's an exception here where you can have a bond and post that as also as proper liability. And this is simply the will of the legislature here, and all we're trying to do is enforce the particular codes in the state. I think that one falls in. I don't see a problem with that. The third one is failure to show, and that's 319. Every licensee shall have his operator or chauffeur's license in his immediate possession at all times when operating a motor vehicle, and shall display the same upon demand of a justice of peace, peace officer, or field deputy, or inspector of the department. Every licensee shall have in his possession when operating and displaying. Every licensee. Well, that's a very interesting argument, Mr. Cook. Every licensee shall have his operator's license and shall display it. And I believe is your contention that there was no proof that you had the license. Isn't that correct?
Yes, sir.
And as I recall from the testimony of the officer, he indicated that you had no license and stated that you did not have one. So if you did not have one, it's obvious that you could not show one. I think we'll have to dismiss that one. Yes, we'll dismiss the failure to show. Okay. Now, as far as the ticket signed under threat or compulsion of this sort of thing, I don't think it's material to the case. The officer has observed violation. He's issued the citations, and the attempt to negate them through duress and coercion is just simply not applicable and is irrelevant at this time. However, for the record, I would just deny it on the grounds, and if you wish to appeal, of course, and it is preserved, and the record's preserved for them. On the intent, the statutory construction comes into play here, Mr. Cook, and we've had numerous motion hearings on these particular issues, but we didn't cover intent, I guess, clearly. There's two types of intent, as you may well know, the malum in se and malum prohibitum, and this falls into the latter category, and no intent need be shown. And I recognize the argument from the criminal aspect that it's been ruled time and time again. It's been upheld by the state of Idaho Supreme Court, and I'm certainly not going to sit here and go against the case law in the state of Idaho in this case or in any other case for that matter. And it's quite clear, so intent need not be proved. It's not an element of the offense in this case, in the cases before the court, so I will deny your motion to dismiss at this time based upon that. Okay, now we're ready to proceed, gentlemen?
Yes, Your Honor. Just for the record, Your Honor, I object to the findings of the court on the prima facie issues, and I want the record to reflect that.
The record is preserved for appeal, Mr. Cook. You ready to proceed now?
My opening statement, Your Honor, so far, I've tried my best to raise a defense to the jurisdiction of this court based on the factual presentations in my affidavit of defense and in the testimonies here. And I feel that none of these facts has altered my position at this time. Simply stated, my position is that short of any factual showing that I have conducted myself in such a way on the highways as to affect the public interest or to injure life, liberty, or property or to interfere with the actions of government, then there should be no jurisdiction taken against me, no actions, criminal or civil, taken against me in this court or any other. I have seen no cause against myself by this government. Nothing in my conduct to this point in time, shown in this court or anyplace else, has shown that I've damaged the operations of government of the state of Idaho in any way. Therefore, I don't feel there's any cause for an action to be taken against me. I would at this time take the stand and give some testimony as to exactly what my conduct has been pursuant to this matter, pertinent to this case. And just to make the record clear upon the face of the record so that I have a good, clear, appealable issue.
Okay, then you want to take the stand at this time?
Yes, sir.
Okay, when taking the stand and testifying, I want you to know that you'll be sworn in, and any information that you do relay in the form of testimony can and will be held against you. Do you understand that?
Yes, sir. I would note, Your Honor, that I will not swear an oath. I have religious convictions against swearing, but I would affirm.
You're willing to affirm the oath? That's acceptable.
I'll affirm for my statements.
That's fine, Mr. Cook. Would you rise and face the clerk of the courtroom? Raise your right hand.
Do you swear to tell the whole truth and nothing but the truth, so help you God?
I'll affirm to tell the truth.
Okay. Would you care to take a witness stand there? Okay, proceed with your questioning. You might move that forward a little bit, please, so this record can be preserved.
Okay. Well, I'm not sure how to proceed. I guess I'll just kind of tell a story.
All right, tell your story, Mr. Cook.
Okay. Back in about 1978, 1979, I began to study the driver's license issue, pursuant to some traffic tickets I had at that time. The more I studied it, the more I was convinced that the traffic codes were simply codes that regulated trade, commerce, and industry on the highways. Commercial regulations having nothing to do with the common right of liberty to travel. I felt that whatever I was doing on the highways was not engaging in trade, commerce, and industry. Studying case law and studying the Constitution, I became convinced that the right of liberty is the right to travel on the highways. The highways in 49.305 of the Idaho Code are considered to be rights of way. And becoming aware of all these facts, then I let my driver's license expire in 1979. I took the plates off the vehicle when they expired in 1981. I quit making any payments on insurance and let that lapse, finding no need for any of the three. Since that time, I've been driving as a matter of common right. I drive simply to transport myself, to visit family and friends, or visit government, or to conduct any business I have to do. When the officer saw me, I was simply driving down the road on my way to the courthouse to deliver some papers pursuant to some other actions I have. And I believe I have an intrinsic right in this government and a natural right of liberty to not only drive on the roads, but to visit my government, to do this kind of thing, serve process or answer process. The officer asked me why I was driving with no license and registration. I told him it was a matter of common liberty It was a matter of inalienable right and constitutional right both. And therefore I informed him of the facts, and yet he proceeded to charge me with a criminal offense. And at this time, I'm in jeopardy of being fined and punished for doing something that is a natural right. And I've denied this court's jurisdiction based on the facts that I've presented. I've done this in motion hearing and here at the trial. And I believe my appealable issue is simply that I can't be deprived of life, liberty, and property without due process of law. This is a summary proceeding here that I've been going through today, and therefore I feel that that's not due process of law. This is designed for the voluntary jurisdiction of the traffic codes. I guess that's about all I have to say.
Okay, Mr. Prosecutor, would you care to cross-examine the witness?
Mr. Cook, we've heard your story and it sounds good, but in government affairs, is not the state of Idaho the sovereign in this case?
I believe you said it about right. In governmental affairs,
yes,
it is the sovereign.
Does not the state, through their elected officials, do they not have the power, the duty, the right to enact laws to govern the use of public facilities such as roads, streets, parks, highways?
Insofar as a road is a public facility, yes. Insofar as a road is a right-of-way, no.
And is it asking too much for the state to set down reasonable rules and regulations pertaining to the people that use the public facilities such as streets, roads, highways, parks, etc.?
I'm glad you asked that. I do agree with regulation of the highways and regulation of travel on the highways. One of the most reasonable regulations is to put up a stop sign and provide a statute that shows that when a person causes an accident by running the stop sign, that incurs a liability on him. It points the finger at him as being the responsible party. That is a police power regulation, and it's a valid one. However, to charge a man with running a stop sign when there was no accident is not due process of law. There's no victim present.
But Mr. Cook, what happened if everybody would run around not stopping at stop signs? The purpose of the stop sign, the regulation, is to prevent accidents. That is the reason of government, to protect people, to protect property.
Well, I'd object to the question, Your Honor. We're not having a philosophical conversation.
I tend to agree. I've been patient up to now on both sides of this, but the issue before the court is still operating without registration, failure to insure, and we've dismissed the one on failure to show the driver's license because of the wrong charge there. Let's stick to the issues, I think, at hand before the court, on both of the parts.
Your Honor, the state's trying not to do just nothing but show the attitude of this defendant and show why, or protect the state's interest in concerning why he is running around with apparently his own idea of what the law is and trying to bring in an argument on some nebulous grounds that really has no bearing in this case, and therefore that was a reason for the line of questioning.
I understand the lines of questioning from both sides. I think this was covered sufficiently in pretrial motions, though, and the court has a heavy schedule, and I would like to get on to the other cases at hand, and I think these things have been covered sufficiently in pretrial, and we're just establishing the record now and trying to get the facts as they are, in addition to the two charges before the court. And I'd like to ask both you gentlemen to keep within those limits, if you would, please.
Yes, Your Honor. At this point, I think the state would have no further questions then.
Any redirect, Mr. Cook?
No, Your Honor.
Okay, would you like to take your seat? Would you like to call any other witnesses, Mr. Cook?
No, I have none, Your Honor.
You don't want to re-examine the officer or anything at all?
I would like to call the officer back for a couple of questions.
Is Officer Dempsey still in the courtroom?
Here you are.
Would you please take the stand, Mr. Dempsey? Mr. Dempsey, I'd like to remind you that you're still under oath, please.
Yes, Your Honor.
Mr. Cook.
Mr. Dempsey, one more question really is about all I have. Did you see an accident at 6th and Grove concerning my driving on the road?
No, I did not.
Was there any victims of this crime?
I don't know what you mean.
Well, you charged me with 3 offenses. One of them's been dismissed now, but still 2 offenses here on trial today. Did you see any victims as a cause for this criminal offense to be charged?
Well, I didn't see any victims. I don't understand what you're talking about. Cause for a criminal offense.
What exactly of my actions caused the damage upon any person? Was there any victims of my acts?
No. If you're talking about persons or people, there were no victims.
And no persons and no people were damaged by what I've done?
Only the people of the state of Idaho.
And how's that?
Well, because you aren't paying the registration and the driver's license and this type of thing to support the state of Idaho. That's a damage to the people of Idaho, in my opinion.
Well, that I'm not paying the money for these things.
I don't know that for a fact. That's from what you told me. I have to assume that.
But the act of driving down the road in the condition that you've charged, that act had no victims as such?
That is correct.
Thank you, Mr. Dempsey.
Any cross-examination if possible?
Officer Dempsey, could something have happened by Defendant Cook not having the driver's license and the proof of insurance, etc.?
Well, if Mr. Cook should get into an accident and cause a damage to somebody's vehicle with no insurance, so that person would not have any coverage to pay for any medical or physical damages to his vehicle.
That's my point. And does not the state, when they issue the license, do they not check a person's hearing, vision, and take certain precautionary measures to make sure that that person is qualified to drive on the public roads and highways?
Yes, they do.
Okay. Thank you, Your Honor.
Any redirect, Mr. Cook?
No, Your Honor.
You're excused, Mr. Dempsey. Do you have anything further to present, Mr. Cook?
No. I think I'm ready for a short closing statement, Your Honor.
Okay, I think the prosecutor gets the first shot at that and give you a second shot and let him go again with the third one if he wants one. How's that? Since the state brought the action.
Well, Your Honor, this is a simple case. Here we have a defendant who apparently feels that he has the right to use the public roads without any regulation or without any qualifications, whatever. And the laws are clear, crystal clear, and they state that he has to have these certain reasonable documents in order to use the public right-of-ways, if he so appropriately calls them. And the state will urge that this defendant be found guilty due to the fact that these rules are reasonable and that something could have happened that would be harmful to the citizens of the state of Idaho. For instance, he could have, his vision might be impaired that would be detected if he'd applied for the license, and he could have caused an accident by not having the license. Somebody could have been hurt because he wouldn't have insurance to help cover the expenses of the medical care or treatment or whatever it would take. So the state would urge this defendant be found guilty and be fined for not having these necessary papers that are provided for in the Idaho Code.
Okay, Mr. Cook?
Well, Your Honor, the counsel statements are perfectly exemplary of what I've been trying to say. The whole action here that has come upon me is taken upon the potentiality of something happening. I'm being charged here with the crime of the future. I'm being charged with committing something that hasn't happened yet. My simple conduct of driving down the street had no victims, as plainly shown here. Nobody's life, liberty, and property had been damaged. There was no interference with governmental structure or governmental activity alleged. It was not even alleged that I was a nuisance to the public. And yet this prosecutor wants to see my property taken and possible imprisonment for a term because I was doing something that had a potential in the future somewhere. I'll remind the court of a maxim of law that says that the law regards only the immediate outcome of the act, not the future outcomes of the act. I believe that's an old maxim of law. The problem we have here is that I contend that the minute I started the motor vehicle in my driveway in the morning, I was already committing this same kind of act. The minute I put the car in motion, I'm committing the kind of act that has the potential of causing a damage somewhere. It might be a child standing right behind me that I've run over. It's as much of a crime in my mind in that the common law to put a vehicle in motion as it is to drive it without a license. So therefore, I see no crime here. I see no cause against myself. I see no damage to anyone, and there's been no case established. There's been no case established. And I remind the court again, I've never given my consent to this jurisdiction. I've never given my consent to having my life, liberty, or property taken from me. And this is a fine case for commercial regulation. It's a fine jurisdiction. It's a fine manner. I'm in agreement with regulation of commercial enterprises on the highways. I feel the public has a need to be protected when there's a corporate enterprise going on the highways. But as far as taking a man's life, liberty, and property from him because he drives as a matter of common right, this will not hold up in the constitutional outlook on the situation. If we're just going to stand here and argue over whether or not it's right to regulate this way or that way, then I concede the argument. But when we view it in the light of the Constitution and the rights of the citizen in his own community and his own life and liberty, this case won't hold up. And I realize I'm just arguing into a vacuum, and this court has no choice but to uphold the statutes, but I do want the court to be fully aware of my position. And this is not simply a radical constitutional or constitutionalist view. My view is based on law and research, and I challenge the prosecution, which he has not done to this date, to rebut any of my arguments with substantive arguments instead of rhetoric. Thank you.
Mr. Prosecutor?
I think the state has stated its position clear and well, and therefore we have no further statements.
Okay. Well, I've had a few cases like this before, and I must say that I think I see the point of departure from both arguments, and although I understand the arguments from both sides of the defendant and the state, this court has no jurisdiction other than that granted to it by statute, and must uphold the statutes as written by the legislatures in the state of Idaho. The statutes are clear that you cannot operate a vehicle without a license, you must have a registration, and you must have insurance. And that being the case, and being the case that the officer's testimony and Mr. Cook, of your own testimony and admission to the facts that you have in fact let this stuff expire or quit making payments on it, you do not have it. I have no choice under the statutes of the state of Idaho but to find you guilty as charged of the two offenses. Now, you've raised numerous arguments here before the court, and they're in your pretrial motions, and you've brought several up again here at trial. I've been lenient with you, allowing all this information in. I think you are sincere in your beliefs here, and I think possibly you could try to have some of these type of issues resolved with the state legislature. I don't know if you're interested in the political aspects or not. I'm not trying to give you any advice or guidance. I'm just suggesting that there are other alternatives other than the courts. The courts are going to follow the statutes, the mandates of the legislature. My jurisdiction exists solely by that legislative body, and your arguments on trade, commerce, and industry are most noteworthy, and I find them very fascinating and interesting. However, they have no substance when they're held alongside the statute. As to whether or not they're constitutional or not, I cannot make that decision, as the code is quite clear. and that will have to be handled on the appellate level. And you certainly are free to appeal if you wish to do so. Based on that, I have found you guilty at this time. If you'd like to be sentenced this time, I can do that, or you can come back at your pleasure within 24 hours. How would you like to proceed?
Well, Your Honor, at this time I have a motion for a stay of execution pending appeal, and my appeal is nearly prepared. Now that I've had the trial, I'll be able to perfect it. But I do have this motion at this time.
Okay.
Bailiff. I'll get you a copy after a while.
Thank you.
Well, until I make the sentence, this isn't really applicable. If you want to proceed with this, let me give my sentence, and then we can address this if you wish to waive the 24-hour period for sentencing.
Yeah, I suppose so, Your Honor.
Okay. Based upon your good faith and your intent here, I think you're just trying within the courts to handle your case and to get it before a higher court for appellate process. I don't think there's any criminal negligence specifically in your part. I think you are making a good faith effort to overturn what you consider to be bad law. There's no maliciousness I see in your part, and culpability is certainly very low in that regard. I'm going to fine you $25 on each count, and $12.50 court costs would bring the total to about $62.50. Now, having done that, I'll entertain your stay of execution pending appeal. Mr. Prosecutor, do you have any objections to stay of execution?
No, Your Honor.
Okay. Well, that being the case, it's granted.
Thank you.
Let me sign this. Okay, it'll be made part of the record also, and I'd like to remind you, Mr. Cook, that the stay of execution pending appeal, you have 42 days to get your appeal in here, and if it's not here at that time, you must either pay the fine or we'll have to put out some type of contempt or some other action will probably follow. Do you understand that?
Mm-hmm.
Okay, is there anything else to be brought before the court?